Thank you so much, Professor Matthew Rimmer, for the kind introduction. I would like to begin by acknowledging the traditional owners of the land where QUT now stands. I pay my respect to their elders, past and present. I recognize that these lands have always been places of teaching, learning, and research. The topic of my presentation is CRISPR patent dispute, impact on future innovation and dissemination. I would start off by looking at what is CRISPR-Cas and what is its significance in public health. Then I will talk briefly about the tension between the patent system and the Nobel Prize system. And then I will focus on CRISPR patent dispute and how it poses barriers to future innovation and equitable dissemination of this technology. So beginning with what is CRISPR-Cas? Now, CRISPR is an acronym for clustered, regularly interspaced, short palindromic repeats. And there are certain special genes called CRISPR-associated genes, and they are abbreviated as Cas, CRISPR-associated or Cas. Collectively, this genome editing technology based on CRISPR and the DNA cutting enzyme Cas is called CRISPR-Cas system. So now we have clarity what is CRISPR-Cas because I will be referring to this term in my presentation. Now, how this technology works. This genome editing tool makes use of the combination of guide RNA, as you can see in this image, with a specific sequence and the CRISPR-Cas machinery to target a specific piece of DNA and precisely make a cut in the DNA. Then that cut is either allowed to repair naturally or the strands of DNA are guided in the repair process. Now, where the DNA is allowed to repair naturally, it will result in curing diseases because a defective gene will lose its function as some of the code will be lost. And where the DNA is guided, where the repair of DNA is guided, not only defects may be fixed, but also new functions, new traits can be introduced in the gene. Now, this tool enables making a mutation in a specific piece of DNA in the human genome by deploying a combination of guide RNA and the CRISPR-Cas machinery. And why it is superior to the existing biotechnological tools, because gene editing is not a new concept, it is already there. How the CRISPR-Cas is superior to the existing tools. It is a powerful genome editing tool because of its programmable nature, ease of use, superior speed, enhanced accuracy, meticulous precision, and cost effectiveness as compared to other tools. Now, what is its significance in public health? It has significance both in public health and agriculture, but I will not be focusing on agricultural aspect. I will focus on the public health. This versatile technology unlocks a wide range of possibilities because it can be applied to any organism that has DNA, including animals, plants, insects, and microbes. Prospective applications of CRISPR-Cas system in the health sector are particularly important because curing genetic diseases in humans has been a long-standing challenge. It has been a long sought-after goal to cure genetic diseases. So this tool can be used to cure a wide range of diseases such as sickle cell disease, color blindness, breast cancer, and many others. In terms of its significance, Professor Klaus Gustafsson, chair of the Nobel Committee for Chemistry, noted, there is enormous power in this genetic tool, which affects us all. It has not only revolutionized basic science, but also resulted in innovative crops and will lead to groundbreaking new medical treatments. Now, I will talk briefly about the tension between the patent system and the Nobel Prize system. In 2020, the Royal Swedish Academy of Science decided to award the Nobel Prize in Chemistry to Emmanuelle Charpentier and Jennifer Doudna for inventing the CRISPR-Cas genetic scissors. Now, this highlights the tension between the patent system and the Nobel Prize system, because the issue of who first invented the CRISPR-Cas genome editing tool has been the subject of a heated patent dispute between two teams. Which are the two teams? One team, which owns CRISPR-Cas patent in the United States, is led by Feng Zhang, while the other team is led by Jennifer Doudna and Emmanuelle Charpentier, who were awarded the Nobel Prize. So one team has the patent. They are the official inventors of the CRISPR-Cas, and the other team has been awarded the Nobel Prize for their contributions to this field. So the patent system and the Nobel Prize system, they are not aligned. Now, I will focus on the CRISPR patent dispute and how it is posing barriers to innovation and dissemination. I will provide a brief overview of the patent law, how it works, because not everyone has a background in patent law. So patents are exclusive rights granted by national governments, and they grant exclusive, certain exclusive rights like right to make, right to sell, right to offer to sell, right to import for a specific period of time, that is 20 years. And after that 20 years period, the technology goes in the public domain and others can copy that technology. Now, the bargain is the patent applicant has to disclose the technology in their patent application, and the society benefits from that disclosure, because you have the patent exclusive rights for 20 years, but your technology has been disclosed to society, and we all know that new ideas, they are built on existing ideas. So the society can benefit from the disclosure of your innovation, and the patent owner will benefit from the exclusive rights for 20 years, because they can keep the competitors out of the market and they can get the financial gain as a result of that. So this is the bargain. Both the private partner, the parties, patentee corporations, and the society, they benefit from the system. Now, what happened in relation to CRISPR patent? In May 2012, the University of California, the University of Vienna, and Emmanuelle Charpentier, collectively CVC, filed a patent application in the United States covering a limited form of the CRISPR-Cas technology. Now, this application was pending. Another team, in December 2012, the Broad Institute, the MIT, and Feng Zhang, collectively Broad, they filed a patent application in terms of the same innovation, CRISPR-Cas technology. Now, in April 2014, the United States Patent and Trademarks Office, USPTO, granted a US patent to Broad. Now, you can notice that the first application was brought by CVC, and the patent was granted to Broad. Now, the current patent system is based on first to file. The applicant who is making the first application, they will get the patent, the others will be out of the race. But this is of old times, when the United States had the system of first to invent. And that system of first to invent, it led to these types of scenarios where multiple inventors, they were claiming the patent, and it all depended on the evidence they could produce to support their assertion that they are the first inventor. And this is a perfect example how the things can unfold and becomes complicated if the actual inventor is not clearly identified. Now, in 2015, CVC's attorneys requested the USPTO to declare an interference proceedings between the claims of CVC's patent application and Broad's patent. The Patent Trial and Appeal Board, PTAB, ruled in favor of Broad, the original party who were granted patent. Unhappy with the outcome, CVC appealed to the United States Court of Appeals for the Federal Circuit, which ruled in the favor of Broad. in September 2018. Now, in June 2019, the PTAB initiated a second interference and ruled in Feb 2022, reconfirming that patents owned by Broad were properly issued. So in the United States, in relation to that specific patent, the position is clear in the United States that the patent belongs to Broad and not CVC. But there are certain other patents in relation to CRISPR-Cas technology, and more than 30 patents have been issued in the United States to CVC. And CVC also owns patents in over 30 countries worldwide, including the EU, Australia, China, and Singapore. The clash is growing in complexity because the position taken by IP offices in other countries is not necessarily aligned with the US position. Now here we need to understand that the patents are granted at national level. We do not have any universal or global patents. The patents are granted by national patent offices at the national level, and there can be differences in their conclusions, in their findings. So this happened in case of CRISPR-Cas because the position taken by the US was not necessarily taken by other jurisdictions, and it added to the complexity of around the patent landscape in relation to CRISPR-Cas. Now, how it is impacting future innovation in this field of technology? CRISPR-Cas research is highly collaborative field. Now, navigating a complex patent and licensing landscape is a cumbersome task for innovators or for researchers who want to work in this field. To maximize public benefit, it is important to ensure open, equitable, and streamlined access to the transformative CRISPR-Cas tools so that follow-on inventors are able to further advance this field collaboratively. Now, legal uncertainty around patent ownership has the potential to discourage future inter-institutional research collaborations in relation to CRISPR. Future innovation in the field of CRISPR-Cas can be hindered if the rival patentee groups deny each other and others access to crucial tools or restrict particular uses under licensing terms. Now, because there has been a rivalry or there has been that battle between two groups, and if they are not willing to collaborate and they are denying licenses to each other, or they are putting restrictive conditions in those licenses, then there will be barriers to future innovation because the follow-on innovators who want to use the CRISPR tools, they will not be able to use those tools and there will be delays. And the transactional costs of going into future innovation will be higher if there is complexity and it is hard to navigate the patent and licensing landscape. Both patentee groups have invested in spin-off companies. Now, this is not a hypothetical concern that there will be barriers to future innovation because both patentee groups, they have invested in spin-off companies. Caribou Biosciences, co-founded by Jennifer Doudna Group, and Editas Medicines, co-founded by Feng Zhang Group. So both teams, they have their spin-off companies. This approach will discourage the openness required for further advances in CRISPR-Cas systems. These spin-off companies are likely to adopt for-profit licensing strategies to safeguard the financial interests of the respective patentee groups. Reliance only on the patent system to incentivize innovation and on market powers to determine the direction of future research does not guarantee that the direction of future innovation in CRISPR-Cas technology will be in line with the public-facing goals and societal needs. Now, the innovation policy, it has the impact on the direction of research. Now, if we leave it to the traditional R&D mechanism incentivized by the patent system, by the 20 years monopoly, and we leave it to the corporations to make those R&D decisions, they are more inclined to focus on wealthy populations in wealthy countries to focus on their problems so that they can make the maximum revenue out of those R&D costs. And they may ignore the public-facing goals that can be achieved or potentially achieved by using this amazing groundbreaking technology. Now, while making decisions on future R&D, universities and corporations will be more inclined to consider their financial interest rather than the public interest. So we need to consider alternative options, how to incentivize innovation in this important field of technology. Now, focusing on barriers to equitable dissemination or access to this technology. The exclusive rights allow patentees to inhibit price-reducing generic competition. Underprivileged populations who cannot afford highly priced patented products are left out. If you can't afford, you are left out of the benefits of that technology. Now, CRISPR is an important platform technology developed by public funding because it was developed by universities, public institutions. If the technological advance resulting from government funding is then privatized and you allow patent protection on that, it requires taxpayers to pay twice. First, the taxpayers are paying for the public funding to support that research, and then when that research when the patent is granted and the price is high as a result of that patent, then the taxpayers, they have to pay higher price, so they are paying twice, which is not justifiable. A complex patent and licensing landscape around CRISPR-Cas causes confusion and legal uncertainty for biotech companies wishing to develop and sell products based on this disputed technology. There is a lack of clarity on which of the two teams, Broad or CVC, should be contacted to obtain the licenses required for commercializing this technology. Now, in addition to causing barriers to access, equitable access, the technical aspect of this dispute is that if a corporation is seeking license to commercialize this technology, there is a lot of confusion around who should they contact, because there are two teams. Certain patents have been are owned by one team, certain patents are owned by the other team, and there are differences in terms of jurisdiction. In US, one team owns patents. In China, in EU, the other team owns patents. So there is a lot of complexity and confusion. So the seekers of licenses, they have higher transactional costs, and it causes barriers in terms of equitable dissemination of this technology. Now, as I said, the technology itself has the amazing potential to revolutionize the public health, but a complex patent and licensing landscape resulting from lengthy and heated dispute between two rival patentee groups about who first invented this technology threatens its future development, commercialization, and equitable dissemination. This problem of providing timely and expanded access to this technology needs to be addressed on a priority basis, because further development, commercialization, and accessibility of this technology can transform human lives by addressing critical health needs. It is the patent law and policy, not the science, that is holding up this life-changing technology and posing barriers to achieving its full potential. Now, the technology has potential and it wants to unlock its potential. The science is not a barrier. The barrier is posed by the patent law and policy, and it is in our control, it is our choice to remove those barriers to make the maximum use of that potential that the technology offers. So that's the ultimate conclusion. Thank you so much for listening to me.